5, 4, 3, 2.
The designated hour having arrived, I call to order this regular meeting of Ansel Glink's Quorum Forum podcast, the podcast local governments need to do business. In the chair, it's me, Daniel J. Bolin, and on the agenda today, it's 20 questions for 2021. We're taking public comment and answering your local government questions for the new year. But first, let's take the roll. We have an attorney at Ansel Glink. She represents and litigates civil rights, wrongful termination, and other claims. She has a New Year's resolution, and we're here to ask her about it. Jamie Such is here.
I'm present, Dan.
Jamie,
my New Year's resolution?
Let's hear it.
It is to take a walk once a day since we've been enjoying this lovely pandemic and not moving as much.
That's a bold claim to say that we're enjoying this pandemic, but maybe you're not. You're saying that in jest. But where are you going to walk on these walks from day to day? Have you scouted out any locations?
Nope. Right now, just living in the city, so take a couple of different directions from my house and check out what's been going on out there since I rarely take walks to the train anymore.
Navigate different parts of the street grid, become a one person neighborhood watch. You're going to start posting on Nextdoor the latest coyote sightings and other interesting observations. That's a good New Year's resolution. Get fit, post comments on the internet. That's going to be outstanding. Next on our agenda, we have we have a law clerk here at Ansel Glink. He's a 3L at DePaul University College of Law. He has a New Year's resolution, and we're going to ask him about it. Rain Montero is here.
Yes, thank you for having me on this podcast, Dan. And my New Year's resolution is to exercise more and eat healthier, although I'm 4 days past due on that resolution, so hopefully it gets started tomorrow.
That's a good a way to implement resolutions. Diet starts tomorrow. That is my personal mantra. Back in the day when I would go to bars, they would promise free beer tomorrow. And that was not as fun. But a good, healthy, responsible resolutions, all behind the glass, way behind the glass for our protection is Engineer Rick. He is present, and we have a quorum. On the agenda today, it's 20 questions for 2021. And we've got 2 questions out of the way already, 2 important New Year's resolutions. Folks on the live stream, feel free to share your questions with us in the chat. And as always, listeners at home can email us at podcast@anselglink.com. But we've got 18 more questions to get through. So without further ado, question 3 for 2021, Rain. Can employers require employees to get the COVID-19 vaccine? What do you say?
Under certain circumstances, yes. An employer can require employees to receive the vaccine when an employee poses a direct threat to themselves or others when in the workplace unvaccinated. And looking at whether a direct threat exists, factors to consider for employers are the duration of the risk, the nature and severity of the potential harm, as well as the likelihood and imminence of the harm. Healthcare and public safety workers are likely to satisfy this standard, but it could get tricky for other industries. It's also important to note that a mandatory vaccination policy will be subject to exceptions for employees with religious beliefs and disabilities, which would prohibit them from getting vaccinated. And because of the uncertainty of future liability, it's better for employers to encourage their employees to get vaccinated rather than mandate it. The EEOC actually places fewer restrictions for employers to encourage their employees to get vaccinated, and a voluntary vaccination actually eliminates the requirement of discussing the 4 factors for each employee. And just in any event, an employer should be careful when asking for proof of vaccination. Employers should never ask why an employee did or did not receive a vaccination, because this may cause an employee to disclose sensitive information. And employers should instruct employees to submit copies of only proof of vaccination and no other medical documents. And just a last note, vaccine is not a substitute for hand washing, mask wearing, and social distancing. So employers should continue to implement these measures.
This is a timely question. I've personally heard from local health departments starting to reach out to local government employees about getting vaccinated. There's these so-called model policies out there floating around. I've heard about 2 mandating vaccination, and of course, the model policies say, oh, we don't take a position one way or the other, but sometimes communities unwittingly adopt these model policies, and they're really something that you should talk over and think over with your attorney and your staff and your organization. Mandatory vaccination might not be a good fit for your organization, as you pointed out, Rain. Other thought, you might end up getting more vaccination through voluntary compliance than asking for cooperation than requiring it. So that's an important question. Good thoughts. Let's move on. Question number 4. Jamie, can the chair of a meeting have a muted sidebar discussion with the clerk during a virtual village board meeting? What do you think?
They cannot. The Open Meetings Act was amended to allow electronic meetings recently during COVID. And in September, a village board held a meeting on Zoom. The member of the public requested the PAC, Public Access Counselor, to review 2 issues. And it was whether that the board had violated the Open Meetings Act when they muted a portion of the meeting for a sidebar discussion between 2 people, the village president and the village clerk, that lasted about 60 seconds, and whether they were in violation of that Meetings Act because it did not allow members of the public to physically attend. So the PAC found that even though it wouldn't be the case if it was in person, because of the amendment to the act on the Open Meetings Act, they were not allowed to mute themselves because it expressly allowed any interested member of the public to contemporaneously hear all discussions and testimony and roll call votes, which is kind of interesting because had they been in person, it wouldn't have been an issue. Also, they found that it's not a violation of the Open Meetings Act to allow the meeting to be live streamed because it was accessible to the public and satisfied the alternative arrangement.
Yeah, that's huge. This opinion confirms that the no physical public attendance is okay if you make those alternative arrangements and you follow the statute. But this is an important point that virtual meetings aren't the same as in-person meetings. This has changed the way I practice a lot. A lot of the times when I'm sitting there at the dais at the meeting, I used to tug on the chair sleeve a lot and let him know a few things and let him say what needs to be said to get the meeting on track, and so that the chair, him and her or her, look smart, or at least hopefully what I said helped them look smart. But in a virtual meeting, all the communication needs to be heard, and so that's kind of changed the way I've practiced from a practical perspective. But just an important distinction between in-person and virtual meetings. You got to follow those rules.
Yeah.
Rain, if you remember, question 5, how many cannabis business licenses are due to be issued in 2021? If you remember all the way back before the pandemic, everybody was really focused and concerned about making sure that whatever position their community had on cannabis was on the books. And then the pandemic hit, and what happened since then? Tell us what's going on.
Well, Dan, with the pandemic, a lot of these licenses have been delayed. So we have a large number of licenses that are going to be issued in 2021, ranging from community colleges, craft growers, cultivation centers, infusers, transporters, and medicinal and recreational dispensaries. As you said, COVID-19 executive orders suspended many of the deadlines to issue licenses, and the state is still processing applications right now. In 2020, based on the number of tied top scoring applicants, the Illinois Department of Financial and Professional Responsibility was set to hold a lottery for 75 new adult use dispensary licenses to be issued all across the state. And actually losing applicants filed lawsuits objecting to the scoring process. And the state responded by issuing a supplemental notice giving dispensary, craft grower, infuser, and transporter license applicants an opportunity to actually go back and amend their applications and correct any problems. So between the ongoing pandemic and litigation, we unfortunately don't have a good idea of when the state will issue these licenses that were due to be issued in 2020. But the best place to check for updates will be the Illinois Department of Professional and Financial Responsibility Adult Use Cannabis website and the Illinois Department of Agriculture Adult Use Cannabis website.
An important place to look to keep up to date on the latest going on with adult use cannabis. They just reported $1 billion in sales last year, and for adult use and medical cannabis together in 2020. And there's more to come in 2021. Not just the overdue licenses that were due to be issued in 2020, but the statute has more due to be issued in 2021 under the schedule. Of course, we'll see if the General Assembly does anything to change that, or if the litigation does anything to change that. There's any number of factors that could change things, but the folks that thought that some folks who got their cannabis regulations on the books in late 2019, getting ready for cannabis businesses to get going in early 2020. That's not the end of it. We expect more state level applications to come through, and then possibly local approvals being sought in communities across the state. So something for local governments to be mindful of in 2020. Now let's take a look at question 6 here. This is an urgent message for the vehicle owner. We have been trying to reach you about your vehicle's extended warranty. Please call us back immediately at the following number with your personal banking information. Rain, would you mind giving this guy a call back? Meanwhile, I'm going to and make sure you bring your banking information with you. But meanwhile, we're going to move on to the next question here with Jamie, number 7. Jamie, while Rain's doing that, will you tell us whether question 7 are all police reports involving minors exempt from disclosure under FOIA?
The answer is no, it depends. It depends on the type of report that you're seeking regarding the minor and whether it would qualify as a juvenile law enforcement record as defined by the Juvenile Court Act, which is the act that keeps them confidential. In this case, an attorney submitted a FOIA request to the sheriff's department, and he was seeking the police report involving an alleged sexual assault of a minor, but the request was submitted on behalf of the client, the minor's father. So the court, the sheriff's office denied the request, claiming that it was prohibited from disclosure. And the PAC, again, decided that it was not, because it does not qualify as a juvenile law enforcement record. So it should not have been prohibited from disclosure. They should have disclosed it. The court also raised the issue of the fact that public bodies might want to remember to use the privacy exemption as opposed to that juvenile law enforcement record exemption when dealing with a minor.
So this is an important example of, these FOIA exemptions are construed narrowly, and it's important to actually read them and maybe even talk to your attorney about them when they come in, because these are going to be construed narrowly, and the exemption for these juvenile records applies to suspects, but not juvenile victims, like you said, Jamie. And it's an important to apply the exemption correctly. Now, mind you, and I think you noted, the privacy exemption was not raised in this case, and so that might be something for local governments to take away for when these kinds of exemptions come in. So it's not just applying the one exemption correctly; it's take advantage and correctly apply whatever exemptions might apply. So that's important. Rain, I haven't seen that banking information come through yet. I mean, did you call that guy with that information yet? But we'll follow up on that later, maybe offline. But we got, for now, the more urgent question is question 8. What does the new stimulus bill? What does the new stimulus bill mean for local governments?
Well, then, the bill includes a year-long extension of the previous December 30th, 2020 deadline to spend $150 billion provided under the CARES Act Coronavirus Relief Fund for state and local governments. So if local governments have any CRF funds laying around, then they will have until December 31st of the new year to spend the remaining funds. However, the bill does not provide any direct aid to state and local governments. And as far as individuals are concerned, the bill also provides extended unemployment benefits and direct economic relief via stimulus checks of $600 for individuals making up to $75,000 a year. That's $1,200 per couples making up to $150,000, and an extra $600 for each dependent child that is under 17 years old.
Right. So folks might remember that those coronavirus relief funds from the CARES Act, they went to the Chicago and the big counties, and then the state of Illinois for all the downstate counties, and those are the direct recipients. And then local governments might have received allocations from those direct recipients through the local cure program from the DCEO or from the counties or whatever programs that the direct recipients put together. So I don't expect that there is a whole lot of extra cash lying around. I expect, because this stimulus bill came through so late, the extension. I think most folks or a lot of local governments were diligently spending their allocations, but there might be reallocations available at the direct recipient level, and it sounds like that they're waiting for guidance from the Treasury Department for the how that extension is going to be implemented and what that might mean. Might require some statutory changes, at least for the local care program. We'll see the General Assembly's getting ready to reconvene soon. We think. Hopefully everybody stays healthy, stays safe, and then also IDES, the Illinois Department of Employment Security. They're also waiting. They've also been out there saying they're waiting for guidance from the feds on how this unemployment extension extension will be implemented. So waiting on some more guidance. Dear listener, you in the future might be more knowledgeable. That guidance might be available at the time by the time you listen to this. But between now and then, we'll be watching for that guidance to come through.
Yeah, maybe local governments can turn over some couch cushions and some more CRF funds will come up. You never know.
You never know what's maybe folks have some extra funds available, and this extension will be useful for them. That's the hope. In any event, question 9, Jamie, can local governments redact accident reports in response to a FOIA request, even though it provided unredacted reports to a third-party vendor?
The courts are saying yes, they can. The FOIA request was made to the Schaumburg Police Department and requesting a certain police crash report. It was redacted pursuant to the FOIA rules on redaction. And the law firm sued them because they said that the report was available through LexisNexis in the unredacted form. The court First District held that the rights, that LexisNexis, or that the Schaumburg Police Department did not waive its rights to redact the report under FOIA because it complied with the state reporting requirements in submitting it to LexisNexis in its unredacted form. So they still had to redact it for people that requested it through FOIA. And if you happen to have a LexisNexis account and you can get the unredacted version, then lucky you.
So I guess the issue in this case that and mind you, we'll have links to this case and many of the others we've talked about today in the show notes and at quorum.answerlink.com. Make it your homepage. Visit every day, folks. Make that your New Year's resolution. But the issue that the requester in this case raises selective disclosures. Like, how could you provide these documents unredacted to one requester and not the other? This is a transparency law we're talking about anyway. But since in this case they had to provide the unredacted reports to this third-party vendor to comply with the state statute, it wasn't really a voluntary disclosure to a third party because they had to do it. And so they're just complying with the laws. You still, so when disclosing that to a requester, you might want to redact some of that private personal information. There might be some other exemptions you might want to take advantage of then when you're disclosing it to the state for a state purpose to comply with the state law. So, but you want to be careful that you're treating requesters the same and be mindful of that selective disclosure issue, an important issue. Be mindful of in 2021. Question 10, Rain. 2021 is here. Are there any new website posting requirements for municipalities in 2021?
Yes, there are. And I just want to lead by saying that if there are any local governments that have not posted this requirement yet, they should do so immediately because the deadline was January 1st. To comply with the bill, a municipality must post a link to the Illinois Municipal Retirement Fund webpage on its website, which is going to be provided in this podcast show notes. And on the IMRF website, you'll be able to find certain employer costs and participation information, which includes the copies of all resolutions adopted by a municipality after January 1st, 1995 to participate in the fund. An annual report listing each municipality and the date they began to participate in the fund, as well as projected future contributions and past contributions from municipalities going back to that date of January 1st, 1995. Luckily, all local governments have to do is post a link to the IMRF webpage on their website, which shows all of this information. However, as I said before, local governments must do this if they haven't already, because the deadline is
we like complying with laws. If you haven't done it yet, just get out there and do it. I think this was sort of well publicized, but something to be mindful of, to check on. Of course, you don't have to. If you don't have a website, the new law doesn't make you have one, like you said. So just if you've got a website, this is something to post. Check it out in the show notes. Question 11: is there anyone here driving a dented black Prius with the license plate QUORUMPOD? You left your lights on. QUORUMPOD. And anybody with that car, that might be Jamie. That might be my car. So while I go check on that, why don't you answer this next question, 12? How do you know if an organization supporting a local government has to comply with FOIA?
Well, again, famous answer, it depends. It depends on whether that entity supporting organization performed the governmental function for the local government. This was a case that dealt with the Better Government Association, the BGA. They filed a FOIA request to the Metropolitan Peer and Exposition Authority, the MPEA, we'll just call them the Peer Authority, and Navy Pier, who was the nonprofit, relating to records for the operation of Navy Pier. The Peer Authority provided some records, said that they were unable to find others, but the Navy Pier, Inc., the nonprofit company, flat out denied it and said that they were not subject to FOIA. The trial court found that the Peer Authority was required to produce the public records within the nonprofit's possession that related to services that it provided for the Peer Authority. Because the nonprofit performed the governmental function on the Peer Authority's behalf, the records requested directly related to that particular function, they had to obtain them and produce them. However, the court would not go as far as to make that particular nonprofit an actual subsidiary body under FOIA that would make it require it to comply with FOIA as a general rule. They looked at 4 factors for determining a subsidiary and found that a nonprofit was not a subsidiary, and instead that it was a separate legal entity apart from the Port Authority, and that the Port Authority did not maintain control of it, and that the nonprofit was funded without the Port Authority. So you're going to want to look at those factors when determining whether or not you'd be subject to the FOIA and whether you were providing the actual governmental function for that local government.
Thank you, Jamie. I did catch the end of that there after I turned the lights of my car off. But many local governments and park districts have community foundations and park district foundations supporting their local governments. So the question comes up from time to time: whether these organizations need to comply with FOIA. And this is a good example of how a court applies the factors to whether it's a subsidiary body. Do you have to comply with FOIA generally, or if you're doing a governmental function, whether you just have to apply those kinds of governmental function records to comply with FOIA. And so that's a good example of how to analyze how FOIA applies to those kinds of organizations. So question lucky number 13, Rain, this is you. When will newly elected officials take office in 2021?
Thanks, Dan. Well, as a general rule under statute, newly elected municipal officers will be sworn in at the first board or council meeting after the county sends the certified election results to the municipality. So while timing for each county's certification process is different, for the most part, municipalities typically receive results in mid to late April and install their new members at their first meeting in May. But it's important to note that if your municipality has adopted a local ordinance or rule on when new members should be installed, that ordinance will control instead. So, for example, if you receive certified election results on April 20th and your ordinance sets the installation of new members at the second meeting in May, then that ordinance controls and new members should be sworn in at the second meeting in May and not the first meeting. So it's important to check your own local ordinance or code to see if your municipality has adopted a local rule on when new members should be installed. And because this varies from municipality to municipality, if you have any questions, it is always important to consult your village or city attorney.
That's good advice because the answer varies from municipality to municipality, like you said, and you just don't want to do what the neighboring town did. The rules might be different for you depending on what your local ordinance says and when you receive the certified election results. So a good thing to check. That's coming up in April, May of 2021. Something to look forward to this year after these municipal elections wrap up. The April 6th, 2021 consolidated election coming up, and mark it in your calendars. I'm sure many of our listeners already have. So question 14, Jamie, does the Second Amendment protect employees from discipline for off-duty use of a gun in self-defense? What's going on here?
Well, this is an interesting one, actually. The court found that as a matter of first impression, it does not. Because the Second Amendment does not clearly establish a right to use a gun in self-defense. The facts of this case are kind of more fun. We have a city employee, Ms. Calderon, who was a police communications operator. She was off duty, got in a road rage incident with Ms. Garcia. Ms. Calderon shot Ms. Garcia, and then she was indicted for attempted murder. She was later acquitted for those charges based on self-defense. However, the city fired her for violating their personnel code. Specifically, they fired her for shooting Garcia about the body, discourteous treatment, verbal abuse of the public, and conduct unbecoming of a city employee. She was later reinstated, and then she sued the city, alleging that her termination deprived her of her Second Amendment right to keep and bear arms. As a reminder, public officials enjoy immunity from civil liability for conduct that does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. So in order for Calderon to defeat the government's qualified immunity, she would have to argue that the Second Amendment included a constitutional right to self-defense, which was violated when she was fired. The lower court dismissed her claim because of other cases, Heller and Moore, that have only held that there is a right to possess a gun, but not a distinct right to use the gun for self-defense, which the Seventh Circuit agreed. Although I'm sure some people would argue that what good is the gun if you can't use it, but the court did not decide that. The parties did not provide, and the court could not find, a single decision concerning the circumstances in which discharging a firearm constitutes self-defense for the purposes of the Second Amendment. And as a matter of first impression, they cloaked the government with qualified immunity. And also noted that she was not only fired for shooting Garcia about the body, but also that discourteous treatment, the verbal abuse, and the conduct unbecoming of a city employee that she engaged in during her road rage incident. So I guess the takeaway is to be careful regarding the basis of a discharge when it involves a potential issue related to a statutory or constitutional right, especially a hot button issue currently like the Second Amendment. The ruling appeared to be very case specific, so I would make sure to determine whether there is another case directly on point with your exact issue that you might anticipate.
I don't know if it's a fun set of facts, but it is pretty
a little more
wild set of facts. Unfortunate for many folks involved, but from a lawyer's point of view, yeah, that's a really interesting case and kind of reminder for the audience to check in with your attorney before you're going to discipline somebody when like you noted, when a constitutional issue might be involved. And one of our younger incorporated rights and from the Bill of Rights to the states is the Second Amendment. So there's a lot of young litigation popping up around these issues, and and there's new decisions all the time. It's a developing area of law, something to definitely check in with your attorney about. This is an area of law that it is not well settled. But and then another interesting point about that case is it's another example, as we've talked about a couple times recently in this podcast, about qualified immunity and how that works, especially in the ongoing conversation about possible changes to statutory changes to qualified immunity, and the efforts there in the legislature and elsewhere to make changes to qualified immunity. Another example showing how qualified immunity works today and how that helps shield governments from liability in different kinds of cases. So, and there's qualified immunity applies in all different kinds of cases, and not just police cases where they're commonly where a lot of the discussion about changes of qualified immunity comes up. But I'm going on, and it looks like we're running short on time, and we still got to get our way all the way to 20 questions. So to do that, we're going to settle this with a competition that we've played on this podcast in the past. It's been a while. It's called Super Fight. It's a fun game to play with lawyer types. And here we've got. I'm going to assign each of you a fighter, and then you're going to tell me why your fighter would defeat your opponent's fighter using your best lawyer type arguments. Okay, and so I will choose the winner of each round. And then the winner, best two out of three, gets bragging rights for the rest of the year. And it's if you remember how long last year was, like this year, this could be quite the prize this year. So, are you guys ready?
Yes.
Yes, I am.
All right. Question. Here are your fighters. We've got. Rain, you're first on my screen. 101 Dalmatians is your fighter. The top half is relies on sonar to see. So you have 101 Dalmatians, but the top half of the Dalmatian relies on sonar to see. That's does that if that doesn't make sense, that's actually your problem. All right, Jamie, your fighter is a robot in a hot air balloon that has frost breath. So, Jamie, question 15 to you. Why would a robot in a hot air balloon with frost breath defeat 101 Dalmatians, where the top half relies on sonar to see, win in a fight? Please give us your argument.
I would say that he would use his frost breath to freeze them in their tracks.
Oh, they're adorable little puppy tracks.
Yeah.
Okay. Question 16 to you, Rain. Why would 101 Dalmatians using sonar defeat the robot?
Well, I think that the sonar would be an advantage since it's a metal opponent. So, they're going to be able to locate exactly where this robot is. And there's always strength in numbers. So I think the Dalmatians have a good chance of winning this one.
Ooh, that's a compelling argument, and this is the old question: to who would win in the future, organic versus robotic overlords? I think just the numerosity argument got me, Rain. I think you've got round one. Round two, we've got Jamie. You're first. Pick a movie character. I'm going to say SpongeBob and SquarePants inside a giant hamster ball that could only see movement. And then Rain, your fighter is Abraham Lincoln with literal jazz hands and armed with a sadness ray. So, Rain, you go first this time. Why would Abraham Lincoln, with literal jazz hands, armed with a sadness ray, defeat SpongeBob in a giant hamster ball that could only see movement?
Well, for starters, Abraham Lincoln, great president, and if he's got the jazz hands, then he's obviously moving quickly, and really all he has to do to avoid SpongeBob in the hamster ball is stand still, and SpongeBob can't see him. So I think Abe, clear winner in this one.
Of a fair argument. I agree with you. Abraham Lincoln, easily one of our top 46 presidents. Jamie, to you, why would SpongeBob defeat Abraham Lincoln in this fight?
That's a tough one because he's in a hamster ball, huh? I'm not quite sure he's got a very good chance.
You can't take a knee on this one.
All right.
If for only reason we need to go 2 out of 3 to get to 20 questions.
Let's see here. Then I would say that he will use his hamster ball to roll over Abraham Lincoln.
I think that is a compelling argument, and the argument I was looking for. While Abraham Lincoln was our greatest president, his weapon of making you sad actually is not much of a weapon. So I think the brutality inflicted by SpongeBob would be the real difference maker in that competition. So round 2 to Jamie. This is it. The tiebreaker. Questions 19 and 20. Let's see. Grain, your fighter is a gladiator who's really hangry and is 100 stories tall. And then Jamie, your fighter is a velociraptor who can't stop dancing and is riding a horse. Jamie, to you, why would a velociraptor that can't stop dancing and is riding a horse defeat a gladiator who's really hangry that is 100 stories tall?
Well, I guess the raptor would ride the horse around in circles around the gladiator and make him laugh and forget about his hanger.
Would make him laugh? Oh, because of the dancing?
Yes.
Oh,
I'm sure he's got very funny moves.
That is fair. That is fair. Rain, question 20. We made it. The 20 questions for 2021. Why would a gladiator who's really hangry and 100 stories tall defeat this velociraptor?
Well, Dan, I'm going to have to disagree with Jamie on this one. I think, when you're hangry, I'm not sure if anything can make you happy aside from eating. And so, that 100-story gladiator is going to pick that velociraptor right up and probably eat it. So I think that he's got a good chance of winning that fight.
Can I amend my answer?
What if? We'll allow a brief rebuttal and sir rebuttal.
The Velociraptor had the horse. It was a horse, right?
The Velociraptor's riding a horse.
Riding the horse. Well, he sent the horse out for some berries in the woods in order to feed the Mr. Hangry Man.
Oh, so you have facts that I didn't know.
Yes, he got some food.
Rain, any sir rebuttal?
Well, I'm just going to move to exclude this evidence that wasn't admitted before the court. And, I think that the Velociraptor is going to have some pretty hard times giving orders to a horse. I'm not sure if they even speak the same language. So.
This was a difficult competition. I'm very proud of both of you, and it's sometimes you just got to play the cards you've been dealt, and I think the cards this time, 100 stories is really big, and I think that's the difference maker, while Abraham Lincoln could only make you sad, this hangry gladiator, I feel like, is really gonna punish this Velociraptor dancing on a horse. So, congratulations, Ray. 2021 is going to be a good year for you, Jamie. I hope it is for you too. Enjoy these bragging rights the rest of the year, but we do need to move on to the Department of Public Works. It's upcoming speeches, publications, conferences. Folks, I'm Rain, Jamie. I know that the cases and things you talked about today are going to be in the show notes of this episode on Ansel Glink's blogs. Why don't you tell us about them?
So, so I'll just encourage you all to like and subscribe to the podcast as well as Municipal Minute. A lot of these cases and PAC opinions that we discussed are going to be found on the Municipal Minute blog. So I would encourage you all to check them out there in addition to our resources page.
Yep. And Jamie, anything else you'd like to add?
I think Rain said it perfectly.
He nailed it. I do want to mention that Ansel Glink will be at the 2021 IAPD IPRA Soaring to New Heights virtual conference taking place on the World Wide Web, January 28th to 30th, 2021. We've got a lot. We got January 28th, Budget Rehab, How Do You Recover from Coronavirus with Adam Simon. January 20th, we got a legal legislative session with Dirk Price. January 30th, we got a packed slate with the Culture Code, with Dirk Price creating a healthy relationship between executive directors and elected officials. Of course, Not in My Park, regulating controversial park activities, presented by Ansel Glink's Quorum podcast. How about it? That'll be a good one. Tune in to see Adam Simon and Dan Bolin. I know him. Workers' Comp in the Age of COVID-19, Britt Isley and Doug Sullivan will be there. And then Property Brothers with Greg Jones and Kurt Asperuth. And last but not least, We're Watching You. Use of video surveillance in parks and facilities with Scott Puma and Megan Mack. Looks like a action-packed conference, or an action-packed conference for you grammar nerds out there. But Rain and Jamie, I want to thank you for joining us today. Any final thoughts?
Thank you for having me.
Yes, this was my first podcast. It was a lot of fun.
Then that makes this your best podcast appearance of all time, and and I'm sure that'll continue. You know what? I'm sure that you'll appear on future podcasts, and they'll get better and better and better. But in any event, before we go, I want to remind everyone to subscribe, like Rain did, and to leave us a review wherever podcasts are heard. We prefer good reviews, email us your questions and show ideas at podcast@anselglink.com. And leave us a voicemail at 312-604-9178. And as always, visit us online at quorumforum.anselglink.com. Is that enough calls to action? I think so. Can we get a motion to adjourn?
Aye.
All in favor? The ayes have it. We'll see you next time on Ansel Glake's Quorum Forum podcast. Bye.